Hi, and welcome to today's webinar, USPTO's new process for docketing patent applications to examiners and claim drafting strategy. I'm Chris Palmisano, a patent attorney and principal with the Schwegman, Lundberg, and Wessner law firm. I'm joined today by Michelle Forsberg, who's helping to run today's program, and I'm very pleased to introduce our speaker, Drew Hirshfeld. Drew is a principal attorney with the SLW firm, and his current work includes consultation on complex prosecution and litigation matters, and he provides expert witness services regarding USPTO processes and procedures. Drew has a long history as an employee and later as acting director at the U.S. Patent and Trademark Office. He began his career as a patent examiner in 1994 and grew into various management positions at the PTO. He was named Commissioner for Patents in 2015 and performed the functions and duties of the Undersecretary of Commerce for Intellectual Property and Director of the USPTO from January 2021 to April 2022. In that role, he was responsible for the PTO's 13,000 plus employees and an annual budget of over $4 billion. It's difficult to summarize Drew's nearly 30 years at the USPTO, but some of his notable achievements included leading the PTO's response to the Supreme Court's 2021 Anthrax decision by implementing a new process for director review of final written decisions from the PTAB, and he served on the PTO's Precedential Opinion Panel to help decide issues of exceptional importance to the Patent Trial and Appeal Board. Drew also helped to implement tools and procedures for more efficient new application routing, and he implemented extensive patent prosecution training for patent examiners and members of the public. And he spent several years working with the PTO's mentoring program throughout the organization. Drew is a frequent public speaker on important intellectual property issues, and he was named one of Managing IP's top 50 most influential people in IP in 2021. In other words, Drew is uniquely qualified to talk to today's topic about the USPTO's internal processes because he was there helping to build and implement the systems that are used today. One quick note before I hand this over to Drew, we'll be taking questions from the audience, so please use the Q&A feature rather than the chat feature to send in any questions, and we'll handle those questions as time allows throughout the program. And also a link to today's materials will be posted in the chat, so be sure to check it out. And with that, Drew, let's get started.
Well, thank you very much, Chris, for the introduction. It's my pleasure to be here with all of you. My understanding is we have a really good turnout for this event, so I'm very excited about that. As Chris mentioned in his introduction, please use the Q&A feature to send questions in. I am very happy, actually, if you send questions as you have them, so I will try to leave time at the end, but if you have a question in the middle, feel free to ask it, and I've told Chris that he can go ahead and interrupt at any time and get my attention so that we can address the questions in real time. So very happy to do that. Again, it's great to be here with all of you. The topic that I'm going to be discussing is the USPTO's routing process, and I'm going to pull up some slides in a minute, but I just wanted to give you a little bit of background. I think Chris touched on this a little bit in his introduction, but this was actually part of a larger package at the USPTO that took years to implement. So there's really three big changes that I and others worked very hard on at USPTO to make changes for the good of the system. And that is first changing the examiner's performance appraisal plan and updating that plan to be more current. The routing changes, which we're going to discuss today, and examiner time changes. And some of that is actually related to the routing. It's not part of today's discussion unless any of you have any questions about that. But in the aggregate, most examiners got more time to be able to do a high quality job. And those three changes were big. It took a long time to discuss with our employees union to work out the details and to move forward. So I will confess right up front that I feel really good about these changes. So you're getting a very biased view of the routing system. So please keep that in mind as we go forward. But I do think that these are good changes for the system. I'm really excited to talk about the routing. So bear with me for about 2 seconds here while I share the screen. And I will bring up the slides here, and hopefully you're seeing the heading slide, which I'm going to could just go right by. So let me start. And by the way, I'm not actually seeing anybody else here, Chris. So your picture comes off when I share the slide. So you're just going to have to holler if you have a question in the middle. And that's totally
Sounds
fine.
good. Everything looks good, Drew.
Sounds good. Thank you. It's comforting to hear that. So let me start with why are we discussing the new process for, and I called it routing before, or we're docketing now. And let me just say that there's a variety of reasons, right? One, and the first one, which I don't want to lose sight of, is that it improves the application accuracy of the assignment, right? So getting the right cases to the right examiners is of critical importance to everybody. It's a better quality when the examiner is familiar with that technology and positioned to examine it. So it is very critical, and you'll see hopefully today as we discuss the changes why that is really helpful. Also, the second one, and I know this is very important to many people, the way an application is classified controls the way it's routed and docketed to examiners. So first you get a classification, which I'm going to discuss in a few minutes, and then it gets, based on the classification, gets sent to an art unit and to an examiner. And that is, so that process actually controls which art unit and which examiner gets your particular application. And I know that's of peak interest to everybody. And I know that's why there's a lot of interest in this topic. And I'm going to return to it in a few minutes. And then the third reason I wanted to point out is I do think that what I'm going to discuss can assist with your application drafting strategy, because of the importance of getting the classification correct, because of the impact of getting the right art unit and right examiner for your application. I want to show you my thoughts about a strategy that you can use to try to make sure that this process occurs the way it is supposed to occur. And I think that's really important. Before I leave the slide, just a few more thoughts. One, I mentioned these were years in the making, and I know I called it new in the title. It's actually been in place for well over a year, at least a year, but it is new in the big picture because it's a very different process. And again, I'm going to get to some of the details pretty soon. Also, before I leave the slide, I want to describe a scenario that is very, very common, that I'm going to ask that you just keep in mind as we walk through some of these slides. And as background for this scenario, this is basically a similar situation that when I was at the USPTO, I heard very often this exact scenario. I would get calls from attorneys, or I would meet attorneys, and they would describe this scenario to me that I'm going to get to in a minute. And it's happened multiple times. And then since I've been in private practice, even though it's only been just over 3 months or so, 3.5 months, the scenario has raised itself from this perspective as well. So I'm going to ask you to keep this in mind as we move forward. And so here's the scenario. So I would get a call from an attorney, and again, this is usually when I was at PTO, but again, this happened since I've been in private practice. And the attorney says, my application ended up in the business methods area. And now I'm going to struggle getting an allowance, because we all know that the allowance rate in the business methods area is less. That's a whole nother topic, by the way, that we can talk about. But my inventor's invention is really not a business methods. It's artificial intelligence. And how did I end up in a business methods art unit? And I look at the claims, or I hear them discuss it. And as they're discussing it, I'm thinking to myself, or as I'm looking at claims, because I've done both, I'm thinking, okay, you're telling me it's artificial intelligence, but you wrote a business method claim here, right? Or I can see why somebody would think this is a business methods claim. And I'm not faulting anybody. I'm not bringing this up to fault the attorney or fault the examiner or fault the people who are classifying, because it's not about necessarily who's right or wrong. It's about the different perspectives that people have looking at a case. And oftentimes people would complain about the way their application was docketed. In other words, which examiner or art unit has their application. And they were really viewing the application from one perspective, and the office, the people classifying, were viewing it from a different perspective. And I can't say that either was not reasonable, but that's the situation that people find themselves in, and it's very frustrating because people don't feel it's the correct classification. And that's why it's important to understand one, the process, and to think about what strategies we can do to work around that. Now, the example that I gave is business methods and artificial intelligence. This applies across the board, but that I shared with you because that was a very common situation that I saw. Again, we'll keep that in mind. I'll probably refer back to it multiple times here. Okay, so moving on to the next slide, let me talk about a little bit of the background or overview of the old process versus the new process. And I will say, you know, you'll understand this more as I go through the rest of the presentation, but I think it's important to lay the foundation here. So let me start with the prior process, and so I'm looking to the on the left of that column there. And the prior process has been for many years USPC based. That's the United States Patent Classification System. And I'm actually going to contrast it as I go to the new process. The new process is CPC based. CPC based is a cooperative patent classification. It's used by many countries. It's much more comprehensive. It facilitates harmonization. So that's a difference there. Although I will say that the USPTO is still in a transition over to CPC. And so there's more time where they're sort of working in both. Again, that's another topic here. Going to the second difference, and this is an important one, the prior process used one classification symbol for routing an application to an examiner, and the new process uses multiple classification symbols. Are typically used. Obviously, if it's a very refined application or invention, it could be a singular symbol, but most of the time, predominantly, it is multiple symbols, quite frankly, that are based on the entire application and not just the claim. So think about that difference. That's actually a very significant difference. One symbol for routing, which can't be very refined, versus multiple symbols. And this is related to the third area on these columns, for the third row on these columns, and that's that one classification symbol was based on the most comprehensive claim. So the old process was that the people classifying would look at the classification, look at the claims, see what claim is most comprehensive, and that would control its classification. The new process, which is based on the entire classification picture. So it's the claims, it's the specification, it's this entire picture. It's much more accurate to the application. By the way, I do have open on my screen the Q&As. I'm going to leave them mostly to Chris to read because as I'm speaking, I can't read anything lengthy. But I did see one question that somebody came in and said, well, "What does the term symbol mean?" So let me stop. Thanks for that question and address that. So the symbol for classification is where the application is classified. So under the USPC, for example, you might have a class and subclass, like all of the applications, all of the inventions are broken down into classes and subclasses. So you have like a business methods class, and we don't have an artificial class, but you have some classes and subclasses that are artificial intelligence. You have, basically large breakdowns. So a symbol might be like class 706, which is the data processing in the US, and have subclasses. So that would be a symbol. And it's the same for USPC or CPC, and I don't mean the same symbols, they're different symbols, but when I refer to symbols, it's just the nomenclature for the technology classification. So hopefully that answered your question. Returning back to the slide there on the prior process, the last row, you'll see that used to be the SPE's, the supervisory patent examiner's responsibility to docket a case to an examiner's. Whereas in the new process, the initial docketing is done by an automated process. And I'm going to explain what that automated process is soon. But this is an important point for you all to recognize, is that basically in the old process, a technology would come to a supervisor, and that supervisor would then have to remember or know who's the right examiner to do that. And now that's done in an automated way, which I'm going to explain in a quick second. I'm going to actually pause and say, Chris, I know I told you you can interrupt, but I see a number of questions coming in. Again, it's hard to read them as I'm speaking. But is there anything that you want to ask now, or shall we move on and get to the questions after or later?
Yeah, there's one other question we could maybe address now. I'm not sure if we have a slide that speaks to this, but can you speak to the weighting of different aspects or different portions of the application on the new process's use of the entire disclosure rather than, say, the most comprehensive claim?
Yes, I can speak about that, and I'm going to speak about that in another few slides here. So if I may, what I'd like to do is explain a little more about the matching process, and I'll return back to that question. And Chris, if I mistakenly don't get to the question or don't do that enough, then please raise it again here.
Yeah, we'll do. And Drew, when did the new process go into effect? When did that actually
start?
The
new process has been effect. I don't recall the exact dates, but I think sometime in 2020 is when the new process started. So we're well over a year plus into the new process. And as you'll also see, and this relates to the question about the weighting, I do expect there to be multiple iterations from PTO as they learn more information, because this is, there's hundreds of thousands of applications filed. There's 8,000 plus examiners. This new process is actually all of their controls the way they get all of the work that they have for all of those hundreds of thousands of applications. There's about 400,000 new applications. If you can include continuations, about 600,000 a year. So you can see how massive this is. And so I'm expecting multiple iterations. And by the way, I mentioned that the examiner's time was changed. Well, one of the big changes is that the examiner's time, and by time, it's their production time. So every examiner is on a production setting here. So they have to do a certain amount of work in a certain amount of time. It's examination time, and the amount of hours they have for a case is dependent on its classification, at least in part dependent on its classification. So you can see that this is foundational to everything that the PTO does for its examiners. Okay, so let me explain a little bit more about the new process here, and then I'm going to get into the question that was asked as well as some other information. So on this slide, okay, you'll see that the top box is that application classification picture. So as I mentioned, every single application that comes in the door is given this classification picture to it. And so it's as I said, the previous system was a singular data point. The new process is multifaceted. It covers the specification and the claims, basically covers the whole entire application, which is a much more comprehensive and accurate classification picture. So the USPTO now creates this picture for every single application. Then if you look at the second box, that bigger box, you'll see that every examiner now has a portfolio. Now, every examiner always had certain areas that they worked on, but now they have an official portfolio that's created based on all of their actual work, or the actual work that they've done. I think PTO has been using the last 10 years, but that's something that's obviously subject to change. But they look back at what the examiners have actually worked on, and what cases, and those symbols that we talked about, those classification symbols, as they've worked on a certain area of classification, they get a tally, so to speak, and they do up all these tallies so that you know the examiner's portfolio based on their actual work. This is again, new. All examiners had specialties always, but now you can get very refined knowing that the work that they looked at and the work that they've done over the years. because now we're actually tallying it and keeping an electronic portfolio for every examiner. Then I have an algorithm that matches the classification picture of the application to the examiner's portfolios to see which examiners are most qualified for the applications. And this way you might say, okay, this application came in and there's one examiner that's qualified and nobody else is, right? You might say, okay, there's 10 examiners that are qualified, and then PTO can choose between those 10. But this is the new process that is in place, and it's this classification picture matching to the examiner portfolio matching. So again, I think this is a really good way to update the system. Let me give you a very basic example. This is an example I used to speak about when I was working for PTO, and I'll apologize about its simplicity, but it's actually really helpful for explaining the system. So the invention that we're looking at is a gear with a special no-slip coating on it, and so the prior system would go to the most comprehensive claim, which you can assume is the gear and the coating. And it would say, okay, I'm going to send it to the art unit based on that, but it would literally be sent to the art unit that does gears. Then it goes to the, unless there's an art unit that does gears and coatings, which there probably isn't, right? There's probably only a few examiners who do coatings on gears. So this would go to the art unit that does the gears. And then the supervisor would have to remember, okay, who's my coding expert? And maybe they remember, maybe they don't. But that was the old system, and they would docket it to the examiner based on who they thought was the best person to do that. Sometimes, quite frankly, supervisors would docket everything. Everyone would get anything that came to the art unit, and they would do a random, generation of which examiners got which cases to keep it fair for examiners. So that was the old system. Now, under the new system, what will happen is you'll have this classification picture, which instead of just saying a gear, right, will now be a gear with a coating or anything else that's claimed. And then you can look at the examiner's work and say, okay, based on actual cases, these 2 or 3 examiners or however many examiners actually did coatings on gears. So now we know they're the most qualified person, and then the PTO algorithm can decide which person to send it to initially, and that way it goes to them. So that is the automated approach that PTO is using, and you can see, I hope you can see from this how it's an improvement over the old system, because you're really knowing what the examiners have done. You're doing an accurate match to be able to get the case to them. My next slide, by the way, talks about some of the criteria, but let me just talk about the weighting, the question that was asked. So right now, for classifying an application, PTO looks at the entire application, the entire specification, claims, etc. For docketing to examiners, they're looking at primarily the claims, because the examiners who, as we all know, examiners examine claims, right? They examine the whole spec, but the claims are what controls their search and their application or not of prior art, depending on what they find in their evaluation of the patent statutes. And so there was a large amount of discussion about what is right for examiners to have. So I don't profess to be able to tell you the specifics of the algorithm. I think that the PTO is going to continue to update and change that. But examiners are getting cases based on the claims and the claim subject matter. Now, they are retaining a whole classification picture for the entire case, and that helps with future work. But the way an examiner gets work is based on the claim. So hopefully that answered the question. I also wanted, yes.
Drew, there's a couple questions about the public accessibility of some of this information. So, for example, are the examiner portfolios made public, or will anything about the specific algorithm, either is it publicly available now, or will it be made available in the future?
So I don't think that information is available now, and I can't tell you whether, since I'm not there anymore, whether it will be made available in the future. I do know, like I said, I do expect multiple iterations. I hope that this information becomes available, quite frankly, but I don't know the answer to that. And I think as people learn the system and ask PTO, hopefully they'll make it available, but that would be their call of how they want to move forward there. Was there another question, Chris?
Another interesting one is, what does this do to art units and art unit groupings going forward? Is there still a necessity to classify examiners into different units?
Yeah, so that's a question that while I was at PTO, we discussed a lot, and again, since I'm not there, I don't know what will happen, but let me just share the perspectives that we were talking about related to that question. So as the premise of the question makes clear, if you're going to have this matching, do you really need specific art units, right? Do you need people grouped together? And honestly, I can give you pros and cons both ways, right? So on the pro side, it's nice to have art units where you can share experiences and information and discuss people who are examining similar applications to you. So in that regard, I think it's very helpful to still have art units. But then again, with this new process, there certainly has been discussion that you don't necessarily need art units anymore, and you need administrative groupings of people, right? So everyone has a supervisor and is grouped together and can keep their administrative tasks organized and track of their production and time and everything else that goes from an administrative standpoint, but you technically don't need art units the way the PTO has had them in the past. I don't know what direction we'll end up. We never made a full resolution of that discussion. It was more of the recognition that this could really change the underlying foundation of the way PTO is organized. I will also just be really blunt with you all. These changes of time routing and PAP were huge that we did. Probably some of the largest changes that PTO has seen in a long time. I also, when I was there, very much changed the organizational structure of the senior management team. It didn't really affect examiners, but that was a very significant change. I did not have the appetite, honestly, to make another change like this. At that point, I think the office personally at that time needed to adjust. And so I didn't really dive into this too deeply, but we did have those initial conversations, and I'm sure they're continuing at PTO, but your guess is as good as mine at this point of what will occur moving forward. So, one other point I wanted to highlight on this slide is the last bullet of the larger box, and that's something that is a pretty neat sort of occurrence of this new process. Is as examiners take on new technologies, as technologies evolve and the examiner has to do something different than say what they were used to for many years, their portfolios will evolve with the technology because now you're tracking all of that. So a great benefit of this new process is that the examiner's work naturally evolves with the technology, which sometimes, when you're not tracking it this closely as in the past, and you're relying on supervisor memory or primary examiner memory of who did what applications, you don't have that natural evolution. So anyway, I think that is also a pretty nice change that is different from the past. All right. So moving on to the next slide here. This is I've mentioned the algorithm, and I just wanted to give you an idea of the way this algorithm can be weighted. So of course, what's primarily important is the match between the examiner's portfolio and the application's classification picture. That is, of course, key. But as I said, and again, that's going to be weighted heavily towards the claims. At least it was when I was at PTO. I don't expect that has changed at all. But of course, that's foundational. But as I said previously, you might have 5, 10, 15, 20, 2 examiners, right, who who are all qualified to do this. So, excuse me. So you can have secondary criteria or other criteria which help you match the examiner. So, for example, you could look at the size of the examiner's existing dockets and say, okay, well, this examiner has a lot of cases, and this other qualified, they're equally as qualified, and they have half the cases or less cases, and they're in need of cases. So you can use the docket size to be able to do that. Obviously, you want to make sure whoever gets the case is qualified, and that is of course foundational. But when you have multiple qualified people, you can use this other criteria. We were also using it, quite frankly, to look back in the unassigned cases, so things that are not yet on the examiner's docket, and say, okay, well, if there's a lot in the unassigned cases that is going to match the examiner's any particular examiner's docket, we know they're going to have a lot of cases, so that may help you decide where to send this case. So again, the other criteria. So it lets PTO not only improve the accuracy of getting the right case to the examiner, but it also helps them balance workloads, which hopefully helps everybody's pendencies, gets them more uniform and reduces pendency.
Drew, do you happen to know if qualities like seniority or even examiner quality, as might be judged by PTAB reversals, would get factored into the assignment process?
I do, and to my knowledge, neither of those are the criteria that is being used. Seniority, I certainly, yeah, I don't think that it's used to say we want more senior people to have certain applications or not, and then PTAB criteria is not used. I mean, it's arguable for one, a PTAB decision, what that says about somebody's quality, that's a whole nother conversation again. By the way, we're also very happy to have other webinars on all these topics. But I think that quality more falls on the supervisor or a reviewing primary examiner to make sure somebody has the requisite quality and not part of the algorithm. So the answer is neither of those, I believe, are in the algorithm.
Okay, thanks.
You're welcome. Thank you. So a few other final thoughts about the process, and then after, they're not my final thoughts per se, because I'm going to talk about the strategy for drafting that I want to get to. But additional thoughts on the process is that the PTO can designate anyone to modify a classification and or an assignment to an examiner. So if a supervisor, if an examiner goes to a supervisor and says, hey, this really isn't my case because this is what I don't think the classification is correct, and I shouldn't have this, the supervisor, for example, will have the ability to override that and make and adjust the classification. This is quite frankly important because it's one of the checks and balances on the whole process. So while it's automated, you have the manual check and balances, and examiners are highly motivated to get it right, because that classification picture determines not only the cases they have, and they want to have the right cases that they're familiar with, that they're comfortable examining, but it also gives their examination time for the production system. And the last thing an examiner wants, believe me, I was an examiner, so you don't want to have cases that you don't know how to do and then don't have the right hours for your production, because it's really going to be difficult for you to make the requisite quantity that you need to do. So there's always this human check. And by the way, the examiner portfolios, it's not part of the slide, the examiner portfolios can be adjusted also if need be. And this was actually when we rolled this out at PTO, examiners had time to review their portfolios. And if they thought that they were inaccurate for any way, for example, you could have had an examiner who spent time helping out another art unit because they had there was an influx of cases there, and maybe their dockets were less, were drying up or were smaller. So they lended a hand, but that's not what they're going to do moving forward. You were able to adjust their portfolios to account for that type of work. And so I just want you to know that there's checks and balances. There also will no doubt be many iterations. So the snapshot that I'm giving you was the snapshot when I was at USPTO. I haven't been at USPTO now for about 3.5 months. So they could be in the process of making changes. I do expect further iterations. These were massive changes that have been made, and by all expectations, and no doubt they're going to make future iterations and changes and improvements to this. And then could be a whole nother webinar, but USPTO is using artificial intelligence for some of the classification. The details there are evolving, so they're hard to give you a snapshot. Basically, you do have a person putting the classification picture on, but I know that the PTO is using artificial intelligence to help identify the claim subject matter and consistency of the classification symbols that are put on for the claims, and helping identify the claims so those get to the right, or the symbols for the claims so those get to the right examiner. So these just some additional thoughts, and I do think that artificial intelligence is really going to be helpful. By the way, I'm going to go on an aside here, and I won't spend long because I want to make sure I get to the rest of the slides here. But when you think about classification, this whole process, it's like, in my view, it's perfect for artificial intelligence. You have very large numbers of applications that are processed routinely in a similar fashion through large numbers of examiners. There's a lot of data that can be gathered, can be used to train the artificial intelligence to do even better. In my opinion, it fits really well, and PTO is very focused on that for the future. So anyway, let me move on. I'm going to go to now transition. That's hopefully you have a basis of the process. Actually, Chris, I'm going to ask are there any questions on the process before I start talking about how you can use this for drafting your applications.
Yeah, we've had a number of questions come in about continuation and divisional practice. And do you want to address that now or defer?
No, I can address that now. That's
okay.
fine.
So the questions are generally, if one is to file a continuation or divisional, will it always find its way back to the original examiner of the parent, or is there a way to help encourage some of these applications to go to other examiners?
So a very common question, one that I was asked very frequently, both at PTO and in the last 3.5 months post PTO. So for continuation applications, almost always that application is going to stay with the same examiner, and the PTO does that for efficiency purposes. Now there are rare situations where there's some interaction maybe between an examiner and an attorney that warrants that a change be made, but I believe those to be very, very few and far between. So for the vast majority of cases, when you have a continuation application, it is going to the same examiner. For divisionals, it depends on the subject matter. So if it's a divisional case and the classification of that divisional would be under the same examiner, and this is examiner dependent, it's technology dependent, et cetera, then the examiner would still get that divisional. If, however, the divisional is a subject matter that the examiner would not examine, would be somebody else, then that application would go to a different examiner. So in other words, for divisional, which could be different subject matter, the PTO is going to do the right match for the person from a quality perspective, to make sure the examiner is examining the subject matter they're supposed to. Was there other questions on that, Chris? Continuations and divisionals?
I think that covered it for the most part.
Okay, sounds good. So let me move over to the second part of the discussion, and this is my thoughts on a claim drafting strategy that you can use. And again, my perspective is to get it right, and I'm going to explain what I mean by that. And I'll go back to the example I asked you to keep in mind. You don't want to have, and I'm going to use the AI business methods. And again, this is applicable across the board, but it seems to be most predominant with the AI business methods sort of interface. You don't want to have an application that's misclassified for whatever reason, maybe the way you drafted it, maybe the way it was interpreted and you drafted it correctly, who knows, right? Again, I'm working hard not to assign blame or fault to anybody, but you don't want to have an application that ends up in an area like business methods if it's not a business method. I actually will support the examiners in business methods, saying that they're hamstrung through not allowing cases because of the case law. But again, you don't want an application that has a good chance of being allowable if it was written as or interpreted as, say, true artificial intelligence, but it's interpreted like a business method and ends up with a different interpretation and a chance of a much lower allowance rate. And again, I get this question very, very often. So this is my strategy for how you can work around that type of issue. And again, one of my previous bullets was also just understanding this process will hopefully help with different applications in the future and understanding the big picture, which I think is important. So anyway, here's my thoughts. And again, I have the goals here. And what I want to address in the goals is that my plan and approach, again, my strategy is that applications can easily be drafted using the class definition. So the question came in, what is a symbol? Well, a symbol is, as I said before, is the classification picture. So for the gear and the coding, it could be a gear technology could be a symbol. The coding technology could be a symbol. Gears with coatings can be a symbol, right? So all of these symbols are associated with a classification scheme, either USPC or CPC, as I said before, and they all have definitions associated with them. So my advice is to know and use these definitions. It's not like you have to memorize all of them. I'm going to show you where to get them and how to get them and how to use them, but use these definitions to help draft your applications and your claims so that the classification is accurate and you don't have that mistaken classification, that situation where somebody calls me and says, hey, my invention was really artificial intelligence, but it got put into business methods, and now what do I do? Because I want to get it out of there, and you're kind of stuck. So I think using the class definitions in my mind is an easy thing to do and very helpful for getting your application classified. And by the way, this is the way PTO does it, right? We talked about artificial intelligence, or even, and then there's some, I didn't mention it, but there's contractors who are doing the classification. But what they're doing is they're looking at the invention, deciding what the technology is, looking at the classification definitions, and deciding where this fits the right definition. So this is actually the same process that's at the foundational heart of what USPTO is doing. So I'm going to show you how you can easily do that. And I also just think my secondary goal here is if you understand the classification system, to me, I think that's a good way to help your future work, whether that's additional drafting of similar or different technologies, whether it's searching for similar art, or related art, etc. I think understanding that classification system is critical. And I hear a lot about people trying to change the way they wrote claims or applications and try to get it steered to this examiner or that art unit or this art unit, etc. And I thought, well, if you really, maybe it works, maybe it doesn't, and I'm not trying to make any commentary on what others are doing, but if you really understand the classification and what's behind the way applications get routed to examiners, I think you have the best chance to be able to control it. So these are my goals. And let me share this next screen here. This is a snapshot from, it's a screen capture of the USPTO website. And basically, you can Google it and just put in USPTO classification and get there, or you've got the link right on the slide. And here's what comes up. And basically, and here, let me grab the laser pointer. You can do either side. You can go to this, you can choose your CPC or USPC here. These are, again, are the different classification systems. If you know a classification symbol you're looking for, like you'll see, we're going to go through some. PTO puts examples there, by the way. Those are CPC symbols there, but if you know the symbol, you can put it in, and then here you can choose, am I looking for the definition or the scheme? The scheme would be the way it's all laid out and related to other symbols. So this is one easy way if you know the classification symbol. This other side here in the classification text is if you don't know the symbol, and you can put in keywords to try to find out the classification. And again, I'm gonna show you an example here. So let me go to the next slide. So here is what I did. I put in, this is the right side of that previous slide, and this is also a screen capture. I literally put in the words artificial intelligence data processing, and I chose all USPC. By the way, PTO, as I said, is switching over to CPC, but there's a transition period. These definitions are available for either, but the artificial intelligence and data and business methods example that I've been discussing works better in USPC, and that's why I chose it, because of the way of the classification system. So I'm not trying to say USPC is better than CPC. I actually think it's the other way around. But for this example, it made most sense. So I put in the artificial intelligence and data processing, and I chose USPC, and I did the search, and this is what came up. I couldn't capture the whole screen; it was too big. But this is the top of what came up. Came up with these class definitions for class 706 is the first one. You see class definition for class 707, etc. And you can see that the class definition for 706 is, the title of that is data processing and artificial intelligence. So just clicking on that. So all I did was a keyword search, found what seemed like the right class, and selected it. And then I got, so what I did, you could have selected and got there, and then another way. Sorry, I did it two ways. I went back to the other side, and I put in the 706 here, which is what I took from the search that I had done. I put 000 because there's a default. I actually did that for the purposes of the slide, and I'll explain it to you. But PTO auto fills these with an example, and the example doesn't disappear on the right side when you put in something on the left side. So I just literally put 000. It didn't matter, but I put the class 706. I chose USPC, and I chose definitions here, and then I ran my search. And then the next slide is not a screen capture. This is the first one in the chain that's not. But if you look down to the bottom around where you see the pointer, these words, these phrases are part of the definition that came up from artificial intelligence, or some of the key terms that came up from artificial intelligence. So you can see emulation of intelligence, including systems for reasoning with uncertainty, adaptive systems, machine learning systems, artificial neural networks, right? These were all part of what the definition is. And I did this whole process, although I don't have it in the slides. I did it for business methods also, which is class 705. And you can see the definition there is uniquely designed for or utilized in the practice, administration, or management of an enterprise, or in the processing of financial data. Financial data is kind of the easy one, but it's the first part that can get confused and intermixed, so to speak, with artificial intelligence. It's the management of an enterprise. So my point, and in my view, a key takeaway from this discussion is going to the definitions and making sure that your specification and claims have the information in it that fits the definition. And I'm not saying take the whole thing necessarily, but fit a definition, and make sure you don't fit the wrong definition is the best way to make sure you have an accurate definition. So here's my view, or an accurate classification. So here's my view, going back to the example. I think examiners and attorneys look at claims and specs differently. I'm not faulting either. It's just your perspectives, right? So oftentimes you have an attorney who believes they've written something that is artificial intelligence, but broadly speaking, it reads on a business method. And sometimes, quite frankly, I've seen attorneys who purposely write things really, really broad, right? Because they want to make sure they can cover what they can, and they went too broadly. And so they actually captured business methods spec in addition to artificial intelligence, and then they get classified in business methods. So my point of this is using the definitions which are publicly available, easy to get, gives you a basis for some of the key information, words, terms. I hate to just say words because I don't want to, out of context, you don't want to just be adding a word here to say, okay, now we'll be in a different classification, but adding the right phrases and subject matter into your claims and your specification will help you get the right classification picture and get you to the right examiner. So anyway, that to me is the key of what I was trying to get to here. And I'm going to share some final thoughts, and this is my last substantive slide, and we'll still have some time for questions. In my opinion, here, let me take the cursor off here. In my opinion, accurate classification is best for everyone, right? I've been asked a million times. I get calls, how do I game this system? How do I, get away from business methods? I'm just going to be blunt with you all. My view is if you have a business methods invention, then you want to be in the business methods area. The flip side is also true. If you don't have a business methods, and this is the biggest problem, then you don't want to be in the business methods area. And that's, one of the ways this process can help. But accuracy is best for everyone. I get asked all the time about how do I game the system. I will just tell you, it's really hard to game the system. As you can tell, it's a very difficult and complex process. And there's checks and balances. I hear people ask me about change the title, change the spec, and you get a new classification, or change the abstract, rather, I didn't mean to say spec, change the title, change the abstract, and you get a new classification. Look, there's some objectivity to all of this. You change the title, you change the abstract, maybe somewhere along the line, somebody thinks that should carry weight in classification, but with all the checks and balances, I believe PTO is going to get it right because it's in the examiner's best interest for their time, for their just work that they're working on to get it right. So I think it's really hard to game the system. So I'm going to say, don't game it. And the reason why I say that is because you don't want the situation where you try to game and you write, say, I have a business methods, but I'm going to write someplace else, so try to write it as if it's not, or if I don't have it, I'm going to write it so broad, right? Can you end up in business methods? These type of games, in my opinion, just create problems for people. And I'm not just talking the office here, the problems all the way around, right? The inventors and the attorneys. So I would say really, accept that the process is complex, try to figure out how to do it right so you get the most accurate examination of your application and try to avoid any kind of game playing. And I know this last one I have there is a theme, but watch for overbreath. That's just a problem that I see all the time. People want to write broad, and I get why. But be careful when you write broad, you could be doing something that you having an unintended consequence to your classification. Some would say, and it's just a thought here, I'll let you decide whether it's a good one or not, that maybe more narrow, like maybe people need to rethink how they're initially drafting, that having some more narrowness to at least the claims and then broadening them out later might help with getting the accurate classification if you feel like you can get broader claims and deserve broader claims later on. But starting off really broad, just have to be careful with that. I'm not saying you can't do it on certain circumstances, but you've got to watch for overbreath. So that is the discussion. I see that there's questions here. There's more. We don't need to go there. Let me just stop sharing. And I'm happy to address any other questions.
Thanks, Drew. There are a couple of comments in the Q&A about this isn't really a question so much as comments about how you've described the classification system and concern that if examiners are allowed outside of their particular art unit, that then how do we track metrics by art unit or by technology area, or will the codes even become less relevant over time? and whether searching will still be available based on codes or classifications or symbols. And I think if I understood correctly, that you're not talking about abolishing any of the code-based system. That's all still very relevant. It's just that some examiners might have some specialization or tend to get more applications for certain codes rather than art unit per se.
Yeah, no, you're very accurate in your answer, Chris. So thank you for doing that. Though the point of this process is so you have a more accurate classification. It's not to have examiners have broader or less accurate classifications. So going back to that gear and coding example, you want to know which examiner does the codings on gears. And so within an art unit, this process will be able to help you get that application to the right examiner. But if an application comes into that art unit and it includes, subject matter that's way off, we don't want, PTO, and I'll say collectively, all of us, we don't want the wrong examiners examining those cases. So that will get corrected and changed over. So I think the premise of the question is, will this be less accurate because you have, or broader because you have cases going, technology is now going all over, but I think it's the opposite. You want the most accurate. It'll help examiners get the work that they're supposed to be doing. And if they get a case that they're not supposed to be doing for whatever reason, that there's the checks and balances in place to make sure that that's fixed. And by the way, examiners have the opportunity to change their profile. So if for whatever reason your profile evolves, again, you took on cases just temporarily, or you inadvertently did a case and you realized I shouldn't have, there's ways to correct the profiles. And the profiles, by the way, are weighted. So if you do a lot in one area versus a singular case, you do 100 cases over the years in certain classification areas, and you inadvertently did one that's different, it's weighted as well. So that one case won't make that much of a difference, but it can all be corrected anyway.
Okay. Another question, I think we've only got time maybe for one or two more. Another common question has been whether you can speak to any particular mechanisms or procedures to switch examiners or art units after examination is underway, after prosecution begins. And in particular, if claims are substantively amended, is there any opportunity to sort of redirect an application at that point?
So it's very difficult, at least in terms of the same application or even continuation applications, to get a case moved to a different examiner. If hopefully what happens if, say, the specification covers a lot of different embodiments, you can argue that this is actually a different subject matter, which really should have been a divisional, but I guess if there's no restriction. But that would be your best argument, but it's challenging once a case gets on an examiner's docket. They tend to keep that case and keep the continuations. I'm also just going to give you my unsolicited advice, and again, take it for what it's worth. I've been 28 years plus at PTO and 3.5 months in private practice. So ask me in a year, maybe I'll feel differently, but I always tell people, I've been telling people forever, and I've even told people in Schwegman this: if you feel like you're not getting a fair shot from the examiner, bring in the supervisor, right? Reach out to the supervisor. PTO needs to know it. You need to get it corrected. I hear constantly about concerns of retaliation. I don't want the examiner mad at me. They're going to have other cases of mine. I understand that. But honestly, if you're getting a bad deal and the examiner still has your cases, you're probably going to get more bad deals if that's really what's going on. So you might as well get it fixed and address it. But I would not hesitate, quite frankly, to bring in, and obviously the clients need to weigh in on this, I know, and there's a lot of factors. So, but I think people should consider much more than they do, bringing in the supervisors and the group directors as needed in situations.
All right, great advice. Well, we've reached the end of the hour here. I know Michelle has a couple of closing remarks, but Drew, thank you so much for spending your time with us and explaining a little bit of what's going on behind the scenes at PTO. There are a number of questions that we didn't get to. We'll pull a list of those questions and we'll reach out with answers to the extent that we can.
Yeah, that would be great.
So
thanks.
yep.
Thanks, everybody. I appreciate it. I saw a lot of questions coming in, and I know that we had really good numbers for this. So thanks for joining in. Michelle?
Thank you for joining us, everyone, and thank you to our speakers. Drew Hirshfeld will be appearing in a number of upcoming events, including an IP Watchdog Life Sciences Masters 2022 event session, the Incentivizing of Pharmaceutical Innovations in the Biden Administration, on October 25th. He will also be speaking at an Association for Corporate Patent Counsel Bay Area in-person meetup on October 27th for current and prospective members in California. Thank you again for joining us, everyone, and be well.